is meant by law. Among legal practitioners there is also no uniform definition agreed upon. However, most opinions agree that the law is a necessary tool to control and protect the common interests of society. Legal experts and philosophers have tried to answer questions about the definition of law by presenting various theories. English law, which greatly influences the law in Malaysia, is influenced by the three main theories: natural law theory, positivist theory and legal theory as a system of rules. Law enforcement aims to achieve justice, harmony and order in the life of society. Whatever law is practiced in a country, the goal is to create justice. However, in certain circumstances there will be parties who feel that certain provisions actually do not achieve the expected goal of justice. Differences in the interpretation of existence exist due to differences in aspects of life, values, culture, and the way a person thinks. Section 2 Act 1950. When a person expresses his willingness to another person to do or refrain from doing something, with the intention of obtaining the consent of that person to do something or refraining from doing something, then it can be said that the person makes proposal, offer-related willingness of the bidder to enter into a valid and legally binding relationship when the terms, whether express or implied, are agreed by the recipient. Section 2(b) Act 1950. When the person to whom the proposal is made agrees with the proposal, then it can be said that the proposal is accepted. A proposal, when accepted, is a promise. Acceptance related to sign of readiness of a person who has received a proposal to enter into a contractual relationship with the party making the proposal. Section 3 Act 1950. Acceptance must be communicated to the proposer. An intention to create legal relations is intention to establish a legal relationship related to willingness of each party to be legally affected if either party fails to execute its contract. Explanation 2 Section 26 Act 1950. An agreement in which the consent of the promoter is given freely is not void simply because the reply is inadequate, but the impossibility of such a reply may be considered by the court in determining the question of whether the consent of the promoter is given freely. Section 30 Act 1950. Agreements whose meaning is uncertain or cannot be determined are void. Provision requirements are not met as invalid contract. In cancelable contract Section 2(1) Act 1950, an agreement that may be enforced by law on the option of one or more parties of the agreement, but not on the option of the other party or parties, is a void contract. Section 10(1) Act 1950. All agreements are contracts if made voluntarily by the parties eligible to enter into the contract, for a valid return, and for a legitimate purpose, and it is not expressly stated under the provisions of this Act that it is void. Parties should enter any contract freely without any pressure from other parties. Section 10 states that every agreement is a contract if it is made by the free consent of the parties. On that basis, every contract must be voluntarily done without any negative element which affects a person's capacity to make independent decisions. Independent decisions are decisions which are made after due consideration of the effects of a contract on the person. Contract law, sale of goods. Lin offers to buy a horse from Guthing on the condition that if the horse brings good luck to him, he will make an additional payment to Guthing, £5 more, valid unless notified to the potential recipient of the offer to give him the opportunity whether to accept it or not. In this case, Powell v. Lee has applied to a school management committee for the position of headmaster at a school. The committee had decided to appoint Powell, but did not inform Powell of the decision. One of the committee members, without permission, had told Powell that he had been elected headmaster. The committee later changed its mind and appointed others. Powell claimed a breach of contract. Defendant had sent a telegram to the plaintiff asking if the plaintiff had agreed to sell him a bumper hall pen and asked the plaintiff to quote the price of the goods. The plaintiff responded by telegram and stated, "The lowest cash price for bumper hall pen is £900. Defendant continued to send a telegram to the plaintiff stating his agreement to buy the goods at the price stated by the plaintiff km. What the plaintiff did was not a final offer but only a quotation. Defendant, a trader who sells knives, has displayed a folding knife in his shop. Defendant has been charged with violating provision of Section 1(1) of the Dangerous Weapons Restriction Act 1959 for making an offer to sell folding knives to the public to the defendant. Defendant is a manufacturer of a drug called the carbolic smoke ball, advertised in Illustrated London News. The advertisement states that if anyone is still infected with the flu after taking the drug, they are entitled to claim £100 from the company. Court decision: the plaintiff is entitled to £100 as he has accepted the offer offered to the public. Defendant issues a tender circular for the purchase of certain goods. The tender submitted by the plaintiff is the highest bid, but the defendant did not accept it. Defendant has the right to reject the offer because no valid contract exists. The tender announcement is just an invitation to make an offer. A counter-offer is where an offeree responds to an offer by making an offer on different terms. This has the effect of destroying the original offer so that it is no longer open for the offeree to accept. In the case, Hyde v. Wrench 1843 Bear 334, the facts of the case are as follows. On June 6, the defendant offered to sell the land to the plaintiff for $1,000. On June 8, the plaintiff responded and offered to buy it for $950. On June 27, defendant denied the plaintiff's will. On June 29, the plaintiff wrote a letter stating a willingness to buy at the original price of $1,000. Based on the above facts, the court ruled that there was no valid contract as the first proposal was void with a counter-proposal. Defendant is an auctioneer assigned to sell part of John Feldhaus's property and farm livestock. Plaintiff, John Feldhaus's uncle, was interested in buying a horsefinder scheduled for sale. On the 2nd of February he wrote a letter to John Feldhaus stating that he had chosen to buy the horse for £30. In the letter, he pointed out, "If I do not hear the information about the horse, I need it to be mine for £30 15 coins." John Feldhaus did not reply to the letter, still defending having been instructed by John Feldhaus to withdraw the sale of the horse. The offense was committed, and on February 25, the related horse was sold by the defendant. The plaintiff made a decision against the defendant. The court ruled that F's nephew did not disclose his intentions to sell a horse to F. So the contract does not exist and the horse does not belong to F. The Contract Act provides for some principles with respect to acceptance, one of which is specified by Section 2(b). Contract Act 1950, according to section this, an acceptance must be communicated to the bidder before it is complete and binds the bidder. The expression states agreement in section 2(b), it clearly indicates an action of acceptance positive from the recipient of the offer. Herefore, acceptance only takes effect from the moment it is communicated to the bidder. In this case, the court ruled that silence or silence by the recipient of the offer does not prove his willingness to accept the offer. For the conclusion of a contract, Act 1950 is the master act that enforces community contract relations in Malaysia. The 1950 Act became the legal basis for all types of contracts in Malaysia. As long as the provisions do not conflict with any provision in the specific legislation on a matter, then the Act 1950 continues to prevail as the principal law applicable. If there is no provision in the Act 1950 to resolve a matter relating to contract law, or, if any such matter is included by the Act but its provisions are found to be not exhaustive, so English law is applicable under the Civil Law Act 1956, Lee Mei Feng 1990. In the case of Song Bok Yong v. Ho Kim Pui 1968, 1 MLJ 56, it was decided that if there was a conflict of provisions between Act 1950 and English law, then the provisions of Act 1950 would take precedence. Thank you for listening. Hope you enjoy our presentation.